Awesome. Okay, well, more formally, welcome. My name is Cam Rodriguez. I am a data reporter and also FOIA filing machine for the Illinois Answers Project. Today's virtual FOIA training will answer some of the most common questions that journalists and then other frequent FOIA filers have about the process, and then give everyone an opportunity to ask questions about the process as well. So again, the event is hosted by the Illinois Answers Project. If you aren't familiar with us, we're Illinois' nonpartisan, nonprofit news source. We work every day to uncover waste and wrongdoing in government, hold public officials accountable, and lift up solutions to Illinois' most pressing problems. We are published by the Better Government Association, who's been fighting for greater government transparency and accountability for a century. It's our 100th anniversary just a couple weeks ago. You can check out Illinois Answers' most recent work at the link in the chat. But today we're very lucky to be joined by BGA's general counsel and FOIA expert, Matt Topic. I'll give a full intro to Matt momentarily, but let me give you a quick agenda for today's discussion first. We'll be doing a couple of poll questions to start, just because we have a lot of different people here from a lot of different backgrounds and skill levels. So we'll do that here momentarily. Then Matt and I are going to talk through some common FOIA issues and how you can address them. Then after that, we'll leave plenty of time for Q&A. And because of that, we ask that you stay muted throughout the session, but feel free again to type your questions into the chat at any time. And then we will conclude promptly at 2 p.m. to keep everyone on schedule. Like I said earlier, we are recording the conversation. We'll be sharing the recording afterward with you all in case you aren't able to stay for the whole hour or want to share it with someone else. But now to introduce our special guest, Matt Topic, you can see on the screen next to me, is partner at Loevy Loevys. He's litigated hundreds of state and federal FOIA cases around the country. He's trained hundreds of journalists, activists, lawmakers, and individuals on the Freedom of Information Act. He's a regular presenter at Investigative Reporters and Editors, or IRE, conferences, and is frequently quoted in the media on transparency issues. He's also represented journalists seeking access to court records, like the BGA and Illinois Answers Project, quashed subpoenas for sources, defended and counseled against defamation claims, and fought unconstitutional gag orders. Well, thank you, Matt, for joining us today. I don't know if you want to say a quick few words about yourself and your experience
Sure.
in addition to the intro.
Thanks so much for having me. Always happy to talk about FOIA. Excited to meet some new people, see some old friends in the crowd as well. So very much looking forward to doing this, and hope to make this as helpful as possible.
Definitely. Very, very happy to have you here today. So like I said, we'll be doing a quick series of polls to set the table for today's conversation, also to help us get a better idea of, who y'all are and what your familiarity is with, some of the topics we'll be talking about today and what that looks like for you guys. So we should have a poll pop up on your screen. It's pretty short. Give it your best shot. No wrong answers. So yeah. And in the meantime, if you have you want to introduce yourself, maybe when you're done with the poll, you can join the other people who are in the chat who've been doing that so far as well. Okay, so we've got pretty close to everyone who's responded so far. Give it a couple more seconds and then we will close the poll. But for the people who just joined us, we're doing a quick poll just to assess everyone's skill level and who you are, what your interest is in FOIA, and what that looks like for you. So okay, cool. Alrighty, so you can see the results up on your screen. So it looks like it's a pretty solid split between a lot of the different groups, which is really cool. We got good amount of reporters and freelancers, good amount of engaged residents, aren't we all? And then a solid mix of people who have filed FOIA requests and people who haven't. I definitely am sympathizing with the people who got a lot of information back that was very redacted, definitely been there. And yeah, it looks like a lot of people who are more on the beginner end of the spectrum with FOIA as well. So we'll definitely keep that in mind. Thank you guys for filling out the poll. I guess before we get into our written discussion questions, just because we have so many people who are more on the beginner side of the spectrum, Matt, do you want to give maybe just like a quick rundown of FOIA and what you can do with it, and why it is the favored tool of journalists and engaged residents everywhere?
Sure. So FOIA stands for Freedom of Information Act. There's a comparable statute in every state in the country and also a federal statute. Sometimes they're called open records laws or public records laws or sunshine laws or things like that. And what they all have in common is they grant the public access to government records, except in limited circumstances where the law says that something can be withheld. So if you make a valid request, which just means, you know, you've reasonably described what kind of records you're looking for, and there can be some issues with clarity, but generally that's not a huge problem. And you make that request to a public body. In Illinois, that's any towns, counties, anything in the executive branch of the state government, anything in the legislative branches. Some states don't include legislative branches. Basically everything except the judicial branch of government, which has its own separate set of laws, which are not as good. But that if you make a request to one of those entities for records that pertain to the transaction of public business, which is pretty broadly defined, it's really anything about government business, then you're entitled to those records unless the government can prove that there is a basis in the law to withhold the record or redact the record. So that could include things like social security numbers, attorney-client privileged information, company trade secrets, information that would jeopardize an ongoing police investigation. It's a whole long list of things that are exempted. I'm sure we'll talk about some of those, but we start from a presumption that you have access to records. And then, you know, another common feature in definitely in Illinois, and from here on out, I'll just be focused on Illinois, is if a request is denied, you have the ability to file a lawsuit to challenge that. And the burden is on the government to prove that it was allowed to withhold the records. And if you prevail, then the government has to pay your attorney's fees, which has allowed me to build a law practice representing people who typically don't have the tens of thousands of dollars that it costs to take on the government to fight these cases.
Absolutely. Yeah. I know that as a journalist, I definitely appreciate the work that you do, and definitely appreciate, you know, all of the fighting that you guys are doing in terms of making sure that FOIA is able to stay as strong as ever, especially here in the state of Illinois. So I guess you mentioned exemptions earlier, which is something that I think a lot of people run into as a roadblock, maybe when they're first starting out with FOIA. For background, like, you know, there are certain categories of things that are exempted, like Matt mentioned, including, for example, oil rigs or oil wells, which maps of oil wells are a very specific exemption. Other things are things like draft documents, and yeah, just other personal information that might be redacted. So if you've ever filed a request and gotten a massive just sheet of paper that's just black ink, or you know, a big black box over everything, that's definitely a redaction. Usually they'll cite an exemption. But Matt, I guess, what are some things that people might not realize get exempted when they file a FOIA request? And, you know, some common pitfalls that people might run into when they're dancing around like exemption eligible material, I guess.
Yeah, I think one that surprises people who haven't gotten too involved in FOIA already is what's called the deliberative process exemption. So you mentioned drafts, and that is sort of one subset of this universe of the deliberative process exemption. And it basically applies when government officials are deliberating about some matter of government policy or some government decision. All the things that lead up to the decision before the decision has been made, most of those things are exempt. So all the back and forth about what should we do, why should we do it, what are the other options available to us, how much will this cost? Most of that is exempt. And many people are very surprised to hear that, because it sounds like the kind of thing that if there's anything we should be able to have access to, it should be, how did the government make a decision? The theory is that government officials, if their preliminary opinions, if they know their preliminary opinions would be one day disclosed, they would self-censor and they wouldn't be as forthright, because they would be afraid of their initial opinions maybe undermining something they said later or did later. Some states, including Florida, have gotten rid of this exemption, and the world is not ended there. So it is something that is controversial, and there's a lot of desire to get rid of it, but it basically protects the government decision-making process. It also gets horribly over-asserted. It gets asserted over things that aren't really part of any decision-making process. It might be an opinion, but it has to be part of a defined or definable decision-making process. So a lot of times that gets overused. It doesn't apply to purely factual information. It only applies really to opinions. And it should really just be, if you imagine a recommendation memo that someone sends to a supervisor, there might be, there's to, from, CC, date, subject information. None of that should be withheld. There might be like, you've asked me to take a look at this question. Here's a factual background. None of that stuff should really be exempt. When it gets into like, this is what I found, this is what my recommendations are and why, that's when you run into that exemption. So I think, that's definitely one that happens a lot, and that tends to surprise people who don't already know about it.
For sure. And that would be something that you would run into if you were requesting for, like, for example, like emails or memos, right? Like that's something that you would get a lot of redactions back for.
Yeah, exactly. It's especially in emails, potentially in text messages too. Which is a fair point to raise here. Like, it doesn't matter what the format of the document is. It doesn't even matter if it's on a personal device or account. If it relates to public business and it's part of someone's job to send it or receive it, then it's a public record.
Absolutely. Well, speaking of different types of public records, I guess one thing that we, at BGA are definitely focused on, but also I think journalists in general and people like me who are data journalists are really interested in are the recent Illinois Supreme Court ruling, which I'm sure you're very familiar with, that ruled on, I guess, like boundaries with exemptions with regards to data sets and schemas and Excel spreadsheets. Would you maybe expand on what that means for journalists and what we can maybe expect moving forward?
Sure. Yeah, happy to do that. So we very often have data journalists or data researcher clients who make requests with an eye towards just understanding what kind of data is in some particular database and how is it organized. And really sophisticated folks can make requests that are literally go to the input box of your SQL database and copy and paste the following language, and then give me the spreadsheet that comes back, right? It's like they can just give like the actual database command that they want to be run. And that's fair game. You can do that. There's a doctrine about not having to create new records in response to a FOIA request, but extracting data from a database, even if that query hasn't been run before, that is not the creation of a new record. So it can be very useful to those folks to have an understanding of how is the database structured, so they can make very tailored, specific requests that take out this sort of human interpretation element and make it a lot cleaner and easier to get the kind of data that they're looking for. And so we would often call that a database schema. And so we litigated a case for someone who was denied access to a Chicago Department of Finance database schema. It was the database for parking tickets and traffic tickets and stuff like that. And again, we weren't looking for the data. We were looking for basically, this isn't your field, if you imagine a database as a series of spreadsheets, it would be just all the column name headings up at the top. And then there would also be information that would show you how those are all laid out, because in a database, you might have 1,000 different tables and they're linked together and they're structured in a particular way. And knowing the structure is important, but certainly knowing the names of the fields are important. So the city claimed an exemption for basically a computer database technical information that has a long list of things on it, one of which is a quote file layout. And then it has a catch-all at the end that says, in any other records that if released would jeopardize the security of the system. And so we argued that they couldn't prove that it would jeopardize the security of the system. And we won that at the trial court, and we were affirmed at the appellate court, and it went to the Supreme Court. And the city kind of shifted its arguments a little bit along the way to say, well, we don't have to show that it would jeopardize the security of the system, because that part of the exemption only applies to the catch-all of any other records. If it's on the specific list, including like file layouts, the city argued it's just per se exempt. If it is a file layout, the city says we don't have to prove that it would interfere or that it would jeopardize the security of the system to release the file layout. If it's a file layout, it's a file layout. And the Supreme Court agreed and interpreted the statute that if it's on that list, the government doesn't have to prove any harm from release of the records. That really, I mean, I think it was the wrong result, because exemptions are supposed to be narrowly construed. And this was at best ambiguous as how to interpret it. So I don't think they were really faithful to their own decisions that say that you have to narrowly construe requests. It also highlights a bigger problem with FOIA, and it's something that has been fixed in federal FOIA, but has still not been fixed in Illinois. Is that under federal FOIA now, it's not enough just to show that an exemption applies, unless the exemption actually prohibits release of records, and most of them don't. Most of them are discretionary. The government can withhold the document if it wants, but it's not obligated to withhold it. They can choose to release it. So if it's a discretionary exemption, they also have to prove that some harm is likely to result, the kind of harm that an exemption is intended to protect against, if the document was released. And so if we had that in Illinois, we wouldn't be worried about any of this. And I would say it really doesn't make any sense to have exemptions that allow withholding of information if the government can't show any harm is likely to result from release of the documents. And so just looking ahead, I think it's a thing that hopefully the General Assembly will fix and catch Illinois up to federal law, which would also fix this particular issue, which is just one example of that. What that means, though, now is that if you ask for a database schema, you are probably going to be denied, which is unfortunate, and it's a real obstruction for people who are trying to do data research, right? So the best workaround is like if the file layout part really was because our client's request, and I think any request for schema specifically includes not only the names of the fields, but also how they're laid out. If you take out the layout part and you just ask for documents sufficient to show, you know, the identity of each field of data in your database, then I think you probably get around that issue. And I think they would have a hard time saying it would jeopardize the security of the system. So it's a really hyper technical issue. It's got some kind of broader issues to it, but I'm always happy to talk, you know, later on as well. People have specific questions on workarounds on this, but it's, you know, it was an unfortunate decision. I think it was the wrong decision. I think it's terrible policy, and I hope that the General Assembly fixes it.
You and I both feel the same way about this decision, especially as someone who will encounter it every single time I file a data-driven records request. But pivoting, I guess I was curious if you have any strategies kind of in line with the idea of workarounds, any strategies for dealing with undue burden claims. So for FOIA beginners, if you've never filed a records request, one response that maybe some of the more FOIA intermediate people here have received is that their records request is unduly burdensome. So it causes an undue burden for the public body to complete the request in an allotted amount of time. Usually the argument I feel like that I receive is like, we don't have the bodies for this, like we're having to dig across you know, records that haven't been digitized, for example, or we're having to strain our staff in a certain way that we can't complete it within 5 business days. So Matt, do you have any strategies for dealing with those and that process in general?
Sure. Yeah, this comes up quite a bit. It's often abused. Sometimes it's legitimate, but it's something that, like, there's a lot of little nuances to it that can be very important to understand. So if the test is, well, the government can deny a request if the burden of complying with the request in light of the 5 to 10 business day deadlines outweighs the public interest in disclosure of the information. So, like, there's one case that says, even though it would take several weeks of full-time work by multiple employees, where it was stuff where there was clearly a very high public interest. It related to a study about weaknesses in, like, eyewitness identifications in police investigations, and it had garnered a lot of national attention, and there was a request for the underlying data that went into the report. And so that's where the court applied that doctrine, right? But in a lot of cases, a court is not going to say that the government has to spend several weeks of full-time work by multiple people just to comply with your request. So that don't get your hopes up too high that that's the norm. That's really, not the norm. But there's a lot of specifics to how it works. The government can't just deny the request on that basis. The statute says that first they have to tell you that they believe your request is unduly burdensome, and they have to offer you an opportunity to confer about narrowing the scope of the request, which means, they have to make themselves available to talk to you, maybe over email, but I would say really they need to make themselves available to talk to you, to sort of, for you to, like, try to figure out, well, why is this burdensome? What can I do to make it narrower? And it's supposed to be sort of a collaborative process where you try to come up with some agreed set of, some agreed scope. A lot of times that might be as simple as narrowing the time frame. You might have asked for 10 years worth of information, or you just didn't put any date limitation on it. And so sometimes just narrowing the time frame is enough. If you're dealing with emails, if you can identify custodians, or at least, like, by title or by general areas, if not by name, and you provide keywords and you just basically say anything that hits on these search terms, that's what I'm looking for, right? That can be a way potentially to do it. There's no numbers to this. There isn't like X number of pages and then it becomes unduly burdensome. But I would say when you start getting beyond about 200 pages per request, then you're going to start to draw undue burden types of issues, right? So, last thing I guess a couple things I'll say this. So it is under the statute, the government waives the right to assert this defense if they don't respond in a timely manner. And if you've ever made a request to the Chicago Police Department, I can pretty much guarantee you they did not respond in a timely manner. Schools are the same way. The state police is the same. It tends to be law enforcement, and schools are the worst at complying with deadlines, which is a pretty pathetic thing in our democracy, that the institutions that enforce the laws and educate our children are the ones that can't just follow simple rules about, complying in a responsive manner. So if they just don't respond or they didn't respond on time, then they waive the right to assert that. So that's just a very important thing to keep in mind. And then it is a balancing test. So usually they just utterly ignore what the public interest in disclosure is. But I think most judges, like, if you don't make any effort to try to narrow it, they will hold that against you. So we generally say to clients, get them on the phone, try to work something out, try to narrow it a little bit, and see if you can come up with something. Because if they still won't comply, then you tend to be in better shape.
Yeah, I 1000% agree with the get them on the phone method. I am, as people at BGA and Illinois Answers Project know, I've taken over the salary database project that we run. So updating a database of salaries of public officials in the state of Illinois, which requires sending almost 1,000 FOIA requests to every single entity for their salary and payroll information, which I've been doing in the past couple weeks. So I've filed just over 950 FOIA requests. And my phone is ringing off the hook, but it's definitely worth it to respond to those phone calls and then recap the conversation in writing via email. That has been just the best, especially when, which I didn't even think about this, but many FOIA officers, especially ones who are doing double duty as maybe a finance manager or something, reminded me it's the end of the fiscal year for some agencies, and maybe they only have 1 or 2 people, and they, are running up against other deadlines and might need extra time, but they still want to abide by FOIA and want to comply. Like, it's just a matter of, working with the agency that you're with, and yeah, making sure that there's a balance between your needs and the needs of the public with the needs of the agency, and narrowing it if needed and working with them to make it work. And like I put in the chat, we will open up the discussion to an open Q&A session, but just to respond to Sebastian's question really quick, yes, if they don't respond within the 5-day time frame, they do waive the right to claim it as unduly burdensome. So
And let me just add something, because people ask this all the time, that it's not a waiver of anything else. So they can still claim whatever exemptions they're going to claim, and if they claim certain exemptions in response to your request and you sue them, they're not foreclosed from adding new ones when they're sued. What they can't do is, if they lose on a set of exemptions, they can't then say, oh, wait, but now it's these exemptions. So they get one shot once it gets into a lawsuit, but before that, they get to keep on adding, which is incredibly frustrating, but it is what it is.
Well, before we go into the Q&A, just a couple more questions, and a couple big ones that I think will help answer a lot of questions that people have in the chat so far. What to do if you get a denial? So, Matt, I don't know if you want to maybe run down like how you can proceed after you get a FOIA request back that an agency has just outright denied your request, and even if you've popped on the phone and called them and, I don't know, taken them out for coffee or something, like like trying to become their best friend, what happens after you get denied and what you can do about it?
Sure. So the first thing I would say is, like, read the denial letter very closely, and they're supposed to identify the specific exemptions that they're relying on, and they're supposed to provide at least a basic kind of set of facts that would show that those exemptions actually apply. The factual part very often just doesn't get complied with, right? But it's unusual for them not to tell you what the specific exemptions are. So once you have that, go read them. It's not hard to find the statute and read the language very closely, because it's, here's an example I give all the time. So I did the Laquan McDonald case that forced the city to release the video of the murder of Laquan McDonald by Jason Van Dyke. And the city argued that it would interfere with a pending investigation being conducted by the state's attorney's office and the FBI and COPA, or what was then IPRA, the police oversight agency. They claimed that those entities or CPD claimed those entities were investigating this shooting, and that if the video was released, it would interfere with those investigations. Well, when you read the exemption, it says would interfere with a pending investigation being conducted by the agency that is the recipient of the request. And long ago, the city won the argument that every city department is a different entity under FOIA. And so you can't FOIA the city of Chicago. You can FOIA the police department or the fire department or streets and sanitation, but you can't just FOIA the city of Chicago. Right. So, as I said, there was no pending CPD investigation into the shooting, because that's not how the process works. And so one of the reasons we won is the court agreed with us that the exemption couldn't apply because CPD was the recipient of the request and they didn't have a pending investigation. And there just is no exemption for interfering with someone else's investigation. Maybe there should be, but there isn't. Right. So my point is, just read the things really closely. We also won because they just failed to show that it would actually interfere with anything a year after the shooting had occurred. The trade secrets exemption has a similar provision in it. It says it makes exempt third-party trade secrets and other like confidential and proprietary information. Sometimes, if someone's bidding on something, they might submit some information that's a trade secret about how their system works that they're saying the city should buy. Okay, but the exemption says it has to be furnished under a claim that it's proprietary or a trade secret. So if you get a response that says, we got your request, and then we reached out to the company, and the company said that it's a trade secret, then it wasn't furnished under a claim that it was a trade secret. It was just furnished. And then later they claimed it was a trade secret, right? And so a lot of exemptions have like very technical language like that. So the first thing I would suggest you do is read that very closely and see if there's something that just doesn't quite add up. And then push back, and they might give it to you, right? If that doesn't work, you have two ways to get a third party to try to help you. One is you can submit it to the Attorney General's office, has a division called the Public Access Bureau, or also known as the Public Access Counselor. So that's like an administrative review process. It's not mandatory. You don't have to do it first, but you can do it if you want. You have to submit the request for review within 60 days of the denial. And if what you're sending to them is a failure to respond, it gets measured from the date the deadline lapsed. So it's a very short time frame to submit it to the Public Access Counselor, and then they review it. And once in a while, they issue a binding opinion. And when they do that, if the party who loses doesn't like the outcome, they have to sue the Attorney General's office to try to reverse it. But they rarely do that. Out of like thousands and thousands of these a year, they might do like 50. Okay. More often they do these non-binding determination letters, because binding they have to do within 60 days. They can extend it to 90 days. They usually do non-binding determination letters, which are helpful, but it might take a year to get a determination, and it's not binding on the public body. So the public body can say, we don't really care what the Attorney General says. We're not going to comply with that. Especially when we had a Democratic Attorney General and a Republican governor, I assure you the governor's office did not care about what the Attorney General's office had to say about what the governor's office was supposed to make public. So there's limitations to that. It can take a long time, and usually it isn't binding, but that's an option that you can do. Option number two is you can sue in circuit court in the county where the public body is located, or if it's a state entity, I think it's wherever you're located or wherever they're located, right? So City of Chicago, you can sue them in Cook County Circuit Court. The court takes what's called the de novo review, which means the agency doesn't get any deference at all. The judge decides it as if it was from scratch. There's no presumptions in favor of the government, other than they usually, to meet their burden of proving whether an exemption applies, it's not like typical discovery in a lawsuit where you take depositions and do things like that and have a trial. They submit declarations that are signed under penalty of perjury, and those are presumed to be truthful. Like if they say that we have a pending investigation, unless you have some evidence that they don't have a pending investigation, they're probably going to win. So there is some amount of deference that they get that way. That usually goes more quickly than the public access counselor route. And obviously it is binding in a way that most public access counselor opinions are not. And then, as I mentioned at the beginning, if you prevail, then the court has to award you attorney's fees to pay your lawyer, basically, right? If you prevail. And that's not available in the public access counselor process. And if it's a willful violation, which means like they knew they were breaking the law and they did it anyway, then there can be penalties of up to $5,000 per violation. So those are your typical remedies, your only really remedies if your request is denied.
Definitely all good info. With this in mind, maybe we'll go into the open Q&A. I know we've gotten some questions that people have sent in the chat so far, and feel free to continue sending any questions you might have, and we will try to get to all of them. I guess to start, this was back when you were talking about deliberative process with, I think, exemptions, right? Are redlined draft bills submitted to legislators by lobbyists or interest groups included in that exemption?
Oh, that is a good question. I'm going to look at the statute actually for this. Because there's a nuance for the General Assembly that I need to remind myself about. If not for that, it's deliberations amongst government employees. That can also apply to like government consultants, but that means consultants who are either being paid by the government or volunteering, but are only serving the interests of the government and not their own interests. So if a lobbyist is submitting proposed, some again, we're gonna there's a nuance for the General Assembly, but if you gloss over that, deliberations with a representative of a lobbyist who's serving the interests of that client, and that client is serving their own interests, that is not subject to the deliberative process. But that does get claimed a lot, but it's definitely improper. 1 second. I'm just trying to find there is something specific to the legislative process, though, that might be broad enough to capture that. So it says, the exemption provided in this paragraph extends to all those records of officers and agencies of the General Assembly that pertain to the preparation of legislative documents. I would argue that something that was drafted and sent by a lobbyist is not records of officers or agencies of the General Assembly. On the one hand, they are because it's in their possession, but on the other, they didn't create them. So, and that really doesn't seem to be what the intent of the exemption is, but I can't say that I've ever had a case on this. So that might be a somewhat novel question, just because of that kind of peculiar little nuance for the General Assembly specifically.
A great question to start off on.
Yeah, indeed. Good one.
Okay, so moving on to the next one. This question asker, they ask, does the federal exemption, also related to I think exemptions in that process, does the federal exemption being discretionary also relate to the delivery of process exemption? So for example, federally preliminary options can only be withheld if they would create harm / jeopardize security.
I didn't fully understand the question, but if what it's getting at is that deliberative process stuff that we talked about, the foreseeable harm amendment was added to federal FOIA mostly to address overuse of that specific exemption. So yes, if they claim that we're deliberating about something and therefore it's exempt, they have to prove that it would actually harm their deliberations for the information to be released. Some exemptions have harm sort of baked into them. And again, now we're talking about federal FOIA, which is a little bit different from Illinois FOIA. So like there's a harm to ongoing investigations exemption in federal FOIA. There's actually some open questions about whether that foreseeable harm provision modifies the harm requirements that are already part of certain exemptions, because it's been interpreted, the new harm provision, to mean they have to make a concrete and specific showing of how harm not only could but would result if the material was released. And some of those law enforcement exemptions don't say like would harm an investigation, but say could reasonably be expected to harm an investigation, which is a lower standard and easier for the government to meet. So hopefully that addresses the question.
Awesome. Well, next question, which is a series of questions, a very specific situation. I just love how it opens, which is, what do I do with Metra? Which same, but it's sad. There are some delays, even though this person has copied Leah, the public access counselor. There's still a delay on releasing the info about a transportation center's planning process. A bit of a pointed question, but I respect it. Does the PAC do nothing to enforce timelines? So what does that relationship look like between the public access counselor and enforcing timelines for FOIA responses?
Yeah, I mean, they definitely kind of beat their chest about it a little bit and will issue, they'll issue nasty little letters along the way. Like they will say, like, the requester has said you haven't responded, please either respond or explain why you're not responding. And if that doesn't, like, very often what happens is then rather than deal with the public access council review, the public body will just be like, okay, I'll move you to the top of the pile and comply with your request. And then the PAC will close the review once the public body has said that they have now responded to the request, right? And then you can do a separate request review if you don't like the response, but once you get the response, then so that's a technique that sometimes can just get them to move, but sometimes they just ignore that. Like I've had cases where they didn't respond, like especially the Chicago Police Department, they don't respond. You follow up with them, they don't respond. You send it to the public access counselor, they don't respond. The public access counselor rules that, hey, you never responded and that's a violation, and they still don't respond. And then we sue, and then finally they respond like 9 months later. You don't have to go through all that, because once they fail to respond, you can sue if you want to. I typically say to people, make at least one effort to say, hey, I didn't get your response. Can you get it to me this week? And if they blow that off, then, you're off to the races on it. So yeah, I feel like the public access counselor is maybe not as aggressive as I would be if I was the public access counselor and enforcing these kinds of things. I would just do binding opinions like immediately on those. Like it doesn't really require much work to conclude that they didn't respond, right? But yeah, it can be a nudge, but some entities just, you can't nudge them. You need like a sledgehammer, which means you really need to go to court.
Yeah, I definitely feel that. I've I don't know, for some particularly stubborn agencies, I've definitely been known to set up like an autoresponder email every week, just ping them about the request that I sent and making sure they know that I'm still interested, which is a very great and passive aggressive strategy. So this person, it looks like this is a great question. I feel like this is a big one that I had when I was starting out with requesting emails. And so I'm glad that this was asked. So this person once asked their village for communications between the town or village and then a particular group on a drainage project. They asked me to provide what email addresses they should search on. How would I know that? How do I work around this?
Yeah.
I'm happy to answer this too if you want a small break from talking.
Yeah, go ahead, get us started. Definitely.
A way that I definitely would start out with this, because I'm totally with you. Like, how would you know that? I mean, you can request for like a staff roster. I think that's something that is definitely important. If you know like who is involved with the project, that can be even more essential. And like, say if you're interested in just like a mayor, you could request for their email, and then the domain is the ticket. So if it's, say, a private company that's managing this drainage project, like it's a third party, any emails between that company's domain and X person is usually what I do. And then usually I'll throw in keywords there. I'll say like, okay, like emails between the mayor, this email, and then this domain and this company regarding drainage, with the keyword drainage between, and this is important too, you're going to want to provide a time frame, because otherwise it will almost certainly be shut down. But Matt, do you have any other suggestions or comments there?
Yeah, I think those are all really good suggestions. I mean, sometimes they're not wrong in that like a lot of public bodies can't just search the whole email system for search terms. They have to go like custodian by custodian, or maybe they can check the box on multiple custodians. Okay. Now, what they should do is try to engage with you in a discussion to try to work it out, right? But instead, what a lot of them are doing is trying to take advantage of the fact that you, of course, don't know who the right people are. And I've had plenty of cases where we've had to fight over that kind of stuff. So I would say, that typically gets denied, or they do it through the lens of undue burden. And then you can use that provision about saying, well, I want to confer with you. So you tell me, who are the people who were involved in this decision? Like, you don't have any idea? Like, you must have some idea, right, who the people might be. So, and if push came to shove and they wouldn't be cooperative, and you came to me and said, Matt, can you sue on this? I very well might say, yeah, they're being ridiculous. We can just fight it as it is. But if you have some time to work with, you might just start like making some guesses, right? And see what you get back. And then like start with the mayor. If it's something you think the mayor was involved in, I mean, especially if it's a smaller municipality, or the village manager or whoever, just start there. And then you're going to find some names on the emails, and then you can expand your search out for there. You can do a next request for all the names of people that you saw on the emails you already got, and just kind of keep doing that, a week at a time, 2 weeks at a time, and you'll eventually get further. You shouldn't have to do that, but sometimes you have to decide, like, do I want to fight on principle right now, or do I want to try to do a workaround to get my records relatively quickly? And there's no right or wrong answer to that in any given case, right? So it just sort of depends on what kind of time you have to work with. The roster ID is a good one. Yeah, you could, or ask for an org chart, or ask for like your payroll information that shows you everyone who works there, and ask for every job description, right? Like, and then it can get to be like, hey, do you want to respond to my like 10 different requests trying to answer the question myself, or do you just want to cooperate and help me figure out who the right people are? And some public bodies will cooperate. Some will just be obstructionists to the very end. So then you just got to kind of fight your way through that.
I feel like it's very much the concept of like malicious compliance sometimes with things like that. Okay, quick one. Is there a time limit for legally challenging a FOIA officer's response or denial? This is definitely a good one to know.
So I mentioned if you do a public access council review, it's only 60 days. For a lawsuit, it's a 5-year statute of limitations. If you have a request that's more than a year old, I would probably say, let's maybe remake the request and then we'll try again. Certainly more than 2 years old. I mean, you legitimately can do it, but a lot of times, like, let's just try again and see what happens. Especially if it was like denied because there was a pending investigation. And then if you wait six months, the investigation's either maybe it's concluded or it's at least progressed to where like they've already interviewed all the witnesses. So the idea that it's going to interfere with future witness investigation to release a video or something like that would really like go away. So sometimes the facts can change.
Definitely. I'm going to skip through to one of the more general questions, and then we'll definitely make an effort to get to all of them before 2:00. But if not, we'll be sure to make sure those questions get answered, or you can always email info@bettergov.org. And we're happy to also give a hand. And question here is, what do you think about the recent efforts to amend FOIA to include the judiciary, and what implications do you think this would have? I know you talked about it a little bit at the start, but yeah, I guess what are your thoughts on that?
Yeah, I mean, I've been involved to some extent in those. I think what's important to understand is that when we think of judiciary, we think of like judges and the judges' clerks and that stuff. And even under the efforts to reform the statute, that kind of stuff is still not going to be disclosed. Like, you're not going to get emails between a judge and a clerk about a draft opinion that hasn't been like that isn't going to happen. But there's a whole lot of administrative things within the actual, like what we would typically think of as the court system. And then there's a lot of things that are part of the judicial branch that are really administrative entirely. Like, for example, the clerk's office that just runs all the operations. Like, if you wanted to know who works in the clerk's office, and there have been accusations of nepotism and the like in the Cook County Circuit Clerk's office in the past, like, you ought to be able to get that the same way as you can get that for anywhere else, right? And then you have things like pretrial services, and if someone has like electronic monitoring, like some of that gets run through the sheriff, and you can get those records, but the part that's run through a part of the court system, you can't get those. Or the juvenile detention center stuff. Like, there's a lot of things that that are really like administrative, that there's no good reason why they shouldn't be released. And so I think that's a great effort. There's a lot of states that do allow access to this, and hopefully that's something that moves in the next session.
Definitely. This is a very good question that I have thought about a lot, as someone who, again, is somewhat frivolously sending a whole bunch of FOIAs to everyone across the state. But I love how this is framed. No requester wants to be identified as a frivolous FOIA submitter. Do you have any experience with this, and what criteria generate such a claim? What are the ramifications of being tagged as a frivolous FOIA submitter? So if an agency, maybe if you're FOIA in your hometown and you're sending maybe even 3 or 4 requests, and in a year, and people are like, that's way too many, like, what could maybe come out of that for you in the future, and what could you do to mitigate that?
So the question used the term frivolous requester. So that is not a FOIA term. There is no such thing as a frivolous request. I can make a request that says, I request the following documents so that I can immediately burn them without reading them when you send them to me, and you are allowed to do that. You shouldn't, but there is no like frivolous request or frivolous requester. I think what that question is getting at is what's called recurrent requester. Okay. Yeah. And what that does is say, first, it does not apply to news media. It does not apply to nonprofit organizations. It does not apply to academic researchers if the requests were made for those sorts of purposes. So a whole lot of people don't even have to worry about that provision at all. If you don't fall into one of those groups, then there are certain thresholds in the statute. If you make, I think it's more than 5 or 7 requests in a 7-day period, 15 in a 30-day period, or 50 in a 12-month period, then you become a recurrent requester until that time period expires, right? So in a worst scenario, you make one, let's say that it's 5 in a week, or in a 7-day period. It might be 7. Let's just say it's 5. So if you make 6 one week, like in one day, you just make 6 FOIA requests to the same public body, then you got to live with that for a year until that rolls off the back end of the year. So you don't want to do that. You want to kind of pace it out a little bit. 15 within 30 days, same thing, keep track, try to pace it out. It's per public body, so they can't aggregate them together, and they can't aggregate together multiple people they say are like working in unison. Someone tried to do that against like a husband and wife, and that was shot down. Okay. So try to avoid it, and the statute lays out what the numbers are. And just remember that, like, it says a 7-day time period, not a calendar week, and those mean different things. So if you are a recurrent requester, it just means that they get extra time to respond. Instead of there being a hard deadline of 5 business days, which can be extended to 10 business days, it's just a reasonable amount of time. And we don't have much guidance from the courts on what is or isn't reasonable. And I think there may be, I don't remember exactly, but I think they may be able to charge you for search fees that they otherwise can only charge to commercial requesters, which commercial requester is just like, it's not just related to a business. It's narrower than that. It means I'm going to sell the data, or I'm asking for a bunch of names and addresses to send out a mailer, stuff like that.
Definitely.
Good question.
Let me, so this will probably be our last question, just to make sure that everyone is able to get back to their days and be productive and do all those fun things. And we can let Matt go. Let's see. I feel like this is applicable to maybe some of your experience, Matt, with like you were mentioning with the Laquan McDonald case. But let me see. If you're FOIAing a public body that is tasked with conducting investigations, right? So an agency that investigates claims of employment discrimination, for example, is there a good strategy for getting good information without running into investigatory, there we go, exemptions?
Yeah, it's hard. I mean, while an investigation is pending, I mean, technically, the public body has to prove not only that there's a pending investigation, but for each little bit of information they're withholding, they have to separately prove that it would interfere with the investigation to release the information. And so if it's like an unsolved crime, the argument is usually, well, we have a lot, the way we eliminate false confessions or like bad information is by keeping a lot of information non-public, so we can test that against what people are telling us. Or we want to know what a witness actually knows, and that might be kind of skewed if we've already released a video of what happened. The witness might conform their memory to what's in the video. There's a lot of arguments why all that stuff is silly, but that's kind of how the argument goes. So it really, they do have to prove why it would interfere with a pending investigation to have certain things released. They can't just make like a blanket claim. So that's a pretty important one. In terms of like employment discrimination, I guess that'd be like the Illinois Department of Human Rights, or like federal would be like the EEOC. I can't say that I've really addressed that specific context to be able to say, any particular things that would work. But definitely in general, just push back on making sure they explain to you how it would actually interfere with something, especially if all they said was it's a pending investigation.
For sure. Alrighty. So, like I said, that it seems like, just in terms of timeline, that'll probably be our last question. I will say, we're planning on hosting more of these types of sessions in the future. Definitely sign up for our newsletters to stay tuned to that. Our audience team does a great job of keeping everyone in the loop on that. And they also helped put this whole event together, did a great job. I'm trying to respond to some of the more specific questions in the chat that I'm able to answer. But in the meantime, thank you, Matt, for joining us today for this really important session and for answering so many questions and, you know, sharing your expertise. Really, really appreciate it. So thank you.
My pleasure. I just put my email address in the chat. I do not hesitate if you get denied or ignored or have questions, please reach out to me. This is how I'm sending my kids to college. So you're not imposing on me at all. And as I said, we're very often able to represent requesters in Illinois at no charge if you were denied. So you don't have to keep following up every week and every week and every week. You know, it's like the people's court, like, you know, what was it? It was like, don't take the law into your own hands, you take them to court. I probably am dating myself, and a lot of people on this Zoom have no idea that that was the original people's court. But anyway, my point is, I'm always happy to help. Don't hesitate to reach out.
For sure. And we also want to thank everyone, you know, all of you guys for joining us today. Before you go, we have a poll that's on the screen. And we'd love for you to be able to answer that. Like we said earlier, we'll be sharing the recording with you all. So, you know, if maybe you had a colleague who is interested in learning more about FOIA, or you weren't able to make it for the whole thing, you maybe missed the beginning, totally fine. And we also encourage you all to follow us on social media, where, like with the newsletter, we'll be posting updates on you know, different upcoming events like this and related to this that BGA and Illinois Answers Project are involved with. But yeah, other than that, I mean, thank you everyone. Thanks again, Matt. And yeah, feel free to just answer the poll, or gonna try and also respond to as many specific questions in the chat as I can. But thank you everyone for being so engaged during this session.
All right. Thank you.